Personally, I think the NBA ought to do both. I don't think it should be either or. And I don't think it's a case of the NBA is not doing the latter. I think the NBA has spoken out in recent times when it has had to. I think it's really, my view is that we need to go beyond just talking. I mean, obviously you can make statements, make pronouncements, and I think the NBA has done that pretty regularly. But I think we need to now go beyond just making statements to actually doing things that will change some of the ills that we see in society. Well, we need to engage. I think we need to engage a bit more proactively with the actors in society, with government. If government does something that is untoward and the NBA makes a statement, okay.
It shouldn't stop at just
exactly. It shouldn't stop at just making a statement. I think we need to engage constructively with government. And by government, I mean all the arms, the legislature, the executive, and the judiciary, which is our own constituency, really. As you know, the judiciary is the only arm of government that is exclusively monopolized by our profession. So really, I think the NBA has to be playing a much more proactive role than the statements.
Because those who make such claims say that because the NBA is not doing much, that's why you see the body of senior advocates talking, intervening in some issues. That's why you see a group like the Justice Reform Project, starting to take prominence and chasing some of the issues that the NBA should be chasing. What do you think of those groups speaking on behalf of maybe the NBA sometimes, or championing causes that people feel that the NBA should have been championing?
My view is that we must work towards having a united bar, a united profession. But even within that united profession, there will be, different interests. Some might be more concerned about some issues than others. I don't see any harm in different groups like the Justice Reform Project, the Capital Markets Solicitors Association, the Employment and Labor Lawyers Association, for example, speaking about things that particularly concern them. The important thing for me, I think, for the NBA is to make sure that it is a broad church that accommodates everybody and accommodates everybody's concerns as best as it can.
In one of your recent interviews, you described yourself as an independent-minded person who has never received or sought patronage from government. So you'll be able to confront the political class when necessary. You said that, right?
Yes.
But there are those, maybe call them critics if you like, who say that you're not known for any form of activism, and that, well, they don't know whether you'll be able to confront some of the issues when they arise. How would you respond to that?
I think activism comes in different forms. For me, activism is not necessarily about noise. It's not necessarily about making noise and carrying placards. Activism sometimes is about how you go about your business, how you relate. And sometimes I think, you can lead by setting examples, not necessarily by what you say, but by what you do. Personally, I think that the way I have practiced law over the years, the way I have directed the firm that I have the privilege of managing to practice law over the years, is activism in itself, because we have consciously tried not to go with the flow. And everybody's doing it, so we should do it too. That for me is leadership.
If you will, what is your idea of the ideal NBA, the body? What should it be doing? What do you think is the ideal for the NBA, its role?
I think the ideal for the NBA is first and foremost an organization that looks out for the interests of its members. Because I think it is only when the members of the NBA themselves are well taken care of and well looked after that they can perform effectively all the other roles that society expects of lawyers. I think the situation we have now over the years has been one in which the interests of lawyers have been so poorly looked after that lawyers themselves have not then been able to perform the role that society expects of them. Because, as I say to people, the first law of nature is self-preservation. A lawyer who is not able to feed his family is not likely to be able to focus on protecting the rights of members of society. His or her first focus is going to be on, I need to solve my own problems first. So I think the NBA must first look after its members, because by so doing, it empowers those members to look after the rest of society.
The welfare of lawyers. It's one of the greatest challenges facing the legal profession: issues of unemployment, poor pay of lawyers, lack of opportunities, inadequate training for the young army of lawyers. It's an issue that trends on social media from time to time. So what have you done in the past to address some of these issues? And what would you do if you become president of the bar?
What I've done in the past, within the sphere of my limited scope of authority, is, at least with lawyers in our own firm, we've encouraged them as best as we can to try to improve themselves. We've mentored them to try to develop expertise in specific areas of law, because I'm of the view that the day of the jack of all trades, master of none lawyer is long gone. So
specialization?
Yeah, specialization I think is critical.
Do you pay them well though?
By my estimation, we do. I can't really judge, but we have lawyers who've been with us for 12, 13, 14 years. I would love to believe that if we weren't paying well, they would have moved on.
Taking a walk.
Yeah.
Okay.
But in terms of if I succeed in my aspiration to be president of the NBA, I think there's a lot more that needs to be done. But the starting point right now is, I don't think we even have a grip on the dimension of the problem. There's a lot of anecdotal evidence, which I don't dispute, that lawyers are not being paid adequately. But I also know that there are a few lawyers who are being paid adequately.
Because some will say it's just Lagos and Port Harcourt and Abuja.
Well, that is the precise point. We don't know. We don't even know how many lawyers there are in Lagos, Port Harcourt, Abuja, Ikotekpene, Otukpo, Ilesha, Ife. So you can't plan or deal adequately with a problem if you don't know the dimensions of the problem. So my priority, if I'm elected NBA president, is to actually dimension the problem. And also look at the problem not just from the point of view of remuneration, but also look at the problem from the point of view of income generation. Because it's two sides of a coin. I was saying to somebody just this morning that the criteria that we use in the profession now, young lawyer, senior lawyer, which is if you're 7 years post-call or less, you're a young lawyer. And once you become 7 years, 3 days, you suddenly transmute into a senior lawyer. I think it's too arbitrary. I think a more realistic criteria, if we must have one, is lawyers who are in employment and lawyers who employ. Because there are young lawyers who are, using the current criteria, there are lawyers who are 5 years post-call who already run their own firms and themselves employ other lawyers. Now, those lawyers who are employed in those firms, who may also be dissatisfied with the remuneration they get, both the employer and the employee, they're both young lawyers in these circumstances. And you also have lawyers who are 15, 20 years post-call who are still in employment and are also dissatisfied with their remuneration. The fact that we describe them as they're no longer young lawyers doesn't mean that they don't also have a remuneration problem. Yeah. So I think we should look at it more in terms of lawyers who are employed and lawyers who are doing the employing, or organizations that are doing the employing, and then find a way of addressing both sides of that problem.
Let's talk about your vision for the bar.
I joined the profession 31 years ago. And when I aspired to join the profession, it was, aside from the fact that I already had a passion for it, and I guess because my father is a lawyer, so I already had some idea of what the profession was like. But then it was also because it was a dignified profession. It was an honorable profession. if you said you were a lawyer, if you went into a gathering, just the fact that you say you're a lawyer, you know, commanded you some respect. And I'm not talking about the, you know, arms akimbo kind of respect. I'm not talking about arrogance, but just respect that, oh, this must be a responsible member of society.
He's a learned person.
A learned person, exactly. All that has gone. And I think we must do everything we can to bring it back. I mean, same thing with our judiciary. It was, I mean, maybe it was even extreme in those days. You could, you know, if a judge was passing, you'd even hear the decibels, the level of the conversation would go down. Ah, it's a judge.
Out of respect.
Out of respect. That was the kind of aura that our profession had. All that is gone.
How did we lose it?
I think we just allowed standards to fall.
By we, you mean collectively?
Collectively, yes.
Okay.
Collectively, we allowed standards to fall. Because the input, you know, cannot but have an effect on the output. So, back in the day, and I'm generalizing, of course, but back in the day, it was the best of the bar that went to the bench. That's why they commanded that respect, because even when they were at the bar, their colleagues at the bar knew that these were the best of us. So when they went to the bench, it was natural that this was our colleague stepping up to the next level. And that respect went with them. We've lost that. We've lost that because, you know, there are quite a lot of very good judges in our judiciary today. But the truth is, the sense I get is that the majority are not of the same caliber as what we had before. So if you ask me, one of the things we must fix immediately is the entry point. We must make it a lot more stringent. We must make the process for appointing judges a lot more stringent.
So I hear what you say about the entry points to the bench, but let's talk about the bar.
Okay.
Because there's some people would say there's a lot of indiscipline in the bar. And they finger senior lawyers like yourself. I mean, when you talk about corruption in the judiciary, people would say that it's the senior lawyers who are used as conduit from the politicians to the bench. So issues of discipline in the profession, what are you going to do differently about that?
You know, if there's a problem, we are dissembling when we start trying to attach that problem to a particular group and exclude the other group. Corruption and indiscipline in our profession is not a senior lawyer problem. It's a problem in the profession as a whole, both on the bar and at the bench. Just to give you an example, and I'm not, you say again, and we must accept blame across board. So maybe let's take the bar first. It takes two to tango. How do you establish corruption? Typically, if you have a lawyer who is engaged in bribing a judge, there's a communality of interest between the offeror and the offeree. So how does a third party establish that a bribe has exchanged hands? Now, the way we tend to identify that in our profession today is when we see what lawyers might consider to be, in quotes, funny judgments. You know, you think the law is settled, this is clear, and then all of a sudden it's gone in a different direction. So there might be some instances where that happens, but then there's so many cases that are in the middle ground, because that is why you have an appellate system. Judges are human. They're entitled to get it right and they're entitled to get it wrong. Where we do ourselves a disservice is where every time a lawyer loses a case, he now goes out screaming corruption because he lost the case, without considering the fact that, you know, somebody had to win and somebody had to lose. And as I say to my colleagues, you know, if you're selling a product and you yourself are the one going around saying this product stinks, nobody's going to buy it. And then we wonder why we've lost respect in society. So I'm not disputing the fact that there's corruption, but I think we need to dimension it properly.
Let's go to the politics of the elections now. You complained about, you accused the leadership of the Egbe Amofin of lack of transparency and fairness in its endorsement of one of your colleagues as its sole candidate for the elections. But there are those who say that this is an afterthought. You submitted to the process, so why would you turn around and complain about the same process that you submitted to?
So let's start from the question of submission to the process. I was invited to attend the meeting of Egbe Amofin by the de facto leader of Egbe Amofin, Chief Wole Olanipekun SAN. Prior to that invitation, I was aware that one of the contenders or contestants for the office I seek had a familial relationship with Chief Olanipekun. In attending the meeting of Egbe Amofin, I didn't have any idea of how the proceedings were going to be conducted.
So until you started running for office of presidency, you had never taken part in their proceedings?
In the
Egbe Amofin?
No, of course I had.
Okay.
Now, I'm talking about the particular meeting,
one,
yes,
okay.
the particular meeting where the issue of whether I submitted to the process arose. So, I mean, for me, the fact that the leader of the association and one of the contestants had that familiar relationship, of course, it raised an obvious conflict of interest. You know, we're lawyers after all. So when I attended the meeting, my expectation was that something would be done to insulate the leadership from the selection process, at least to give me the comfort that, you know, because I couldn't insist, I couldn't ask the leadership to abdicate its position just because it had a familiar relationship with one of the contestants. We couldn't suddenly change the leadership of Egbe Amofin for that purpose. So a process was set up. And that process, if properly managed, perhaps might have assuaged my concerns. As in, okay, we've set up a committee. The committee is going to look at you guys who have shown interest, and we're going to decide which of you we should support. And the question was raised there and then at the Egbe Amofin meeting that what criteria is going to be used to select? You know, is it how tall you are? Is it your complexion? Is it the number of degrees you have? Is it your international exposure, etc.? And the retort was the committee knows what to do. It is that process that I have said is unfair. Because absent clear criteria that was going to be used, it was obvious to me that this was more a case of we already know where we're going. We're just going through the motions. Yeah,
because the candidates should be aware of what would guide the process.
Exactly. I mean, and some said, I mean, I've heard this subsequently that, it's like a student asking for the syllabus. So, of course, why shouldn't the student ask for this? How do you know what to study if you don't have a syllabus? So, and contrary to what has been said, I did not withdraw from the process as an afterthought. I withdrew from the process immediately. I came to the conclusion that this process is not fair. I withdrew from the process, I believe, in early November. The Egbe Amofin did not take a decision until December. So for those who say I withdrew from the process after I had lost, that's clearly false. You know, and to my mind, if the leadership of Egbe Amofin had handled the process better, then this issue would not have arisen. If they had insulated, if they had tried to create a level playing field, so that the larger body, because at the end of the day, Egbe Amofin claims to be representative of the interest of all Yoruba lawyers. It's quite clear to me today that all Yoruba lawyers don't share the view that the Egbe Amofin has said is the view of all Yoruba lawyers. That is not the case, and subsequent events have shown that quite clearly.